And welcome back to the program. Here's another reason why the left would very much like Joe Biden to be able to appoint a Supreme Court justice, and that has to do with some of the cases that are in the chute right now. I've got Mark Mix from National Right to Work Foundation, National Right to Work Committee on the phone to talk about one of those, actually two of those cases. Mark, welcome to the program.
Vicki, good to be on with you. Thanks for the opportunity.
So when I last talked to you about Janus, the Janus decision, that was the landmark decision on public employee union dues. That essentially, without getting into too much into the weeds, it kind of was an Act 10 for public sector workers nationally. You were talking about getting the refund for the employees who had their dues seized by the union, suing for the refund from the unions. And now we've been going through, I don't know how many years it's been since Janus, 2 years, 3 years since Janus? No one's gotten a nickel back, and you have the union claiming that they don't have to pay because they, quote, acted in good faith.
Yeah, that's right, Vicki. There have been some refunds, but mostly they've come in settlements. Some class action settlements, for example, we got a very large one on behalf of 28,000 employees in the state of Ohio where they're able to go back and get their money back. So there's been some progress on getting money back, but there's no court decision that basically says you must give the money back. Just to recap, you're right. Janus was decided in June of 2018, so basically 2 years ago, 2 years plus a little bit. And that case was prospective, meaning it went forward. They didn't say much about the retrospective nature of the money. But here's what happens when you rule on the First Amendment. There's a legal concept called black letter law, which means as if it was the law from the beginning. So the idea is that, if you're ruling on a First Amendment question, it's as if when you say this is a First Amendment question, you win on that, then the law has been this ever since. Or not ever since, but from the beginning. And so what we said was, well, if it's from the beginning, then these workers ought to be able to go back and get their money back to the statute of limitations. In some states it's 2 years, some states it's 3. And we finally have 2 cases on the docket for the October 9th Supreme Court conference to see if they want to hear arguments in this, because there's been a lot of cases that have worked their way through the court system, and 2 of them are sitting there right now, 2 that we litigated, one called Casanova out of Illinois, which is a class action lawsuit. And then, interestingly enough, Vicki, we have the Janus case up for a Supreme Court conference. And that's the follow-up for Mark Janus, the employee who was the lead plaintiff in the Janus decision back in June.
So the class action suit is what's most interesting, I think, to a lot of people, because you're talking about potentially, if in fact you're successful, this is the Casanova case, if you're successful, what kind of money are we talking about here?
Well, Vicki, it's hundreds of millions for sure, because basically what you say, and that doesn't mean that everyone's going to go claim it, but the potential liability for unions to pay this money back is literally hundreds and hundreds.
They've literally stole hundreds of millions of dollars from employees.
Well, that's right. They've been taking it from them, and as Justice Alito said in the Janus case, that they should have been on alert that this scheme was not going to last for very long, because as Vicki, you and I have talked over the last several years, we had the Knox case out of California in 2012 that we litigated and won, saying that workers had to opt into these special assessments. Then we had the Harris case out of Illinois in 2014 that said, look, these unions, these healthcare unions trying to force moms who take care of their children to pay union dues, this is not right. And every one of these cases touched on a case we litigated way back in 1977 that talked about the First Amendment protections for employees who work for their government not to be forced to pay a fee. And we finally got to that First Amendment question. But yes, the money is really a big deal. But the freedom and the ability for these workers to get their money back is really what this is all about, because this infringement of their First Amendment is real. The court has adjudicated it that way. There's a case out in the Third Circuit. We just filed a supplemental brief where they found that this good faith defense was not a legitimate defense. So we're starting to get some confusion in the circuits, which is what usually triggers Supreme Court interest.
How are they arguing good faith? They're saying, well, we didn't know that we were so obviously violating people's rights, so we acted in good faith. That's what they're basically trying to argue, even though, of course, when we have right to work laws on state books, you have unions that create like a 24-hour window where you're able to opt out of the union. They don't want to refund union dues, et cetera, et cetera. I mean, we have reams of proof that these kinds of groups never act in good faith.
Yeah, that's right. On the one hand, when they're collecting your money as a condition of your employment, that's good faith. But when you ask them to get out of it for some reason, whatever reason, there is no good faith there. It's completely bad faith. So you're right about that. And It's about the money, Vicki. It really is. I mean, these people claim to represent workers, but yet they won't let people out that don't want to be with them or associated with them. I mean, that doesn't sound like very good. Well, first of all, it's a great business model, but it doesn't sound very customer friendly in my mind.
They don't have the money to pay they don't have the money to pay the settlements. That's what they're most worried about, is that if it's hundreds of millions of dollars over the course of the past, I don't know, grab, whatever election year spending you'd like to see has flowed into the coffers of the Democratic Party at an enormous rate. And so, number one, they don't have the money. Number two, they won't have the money to continue to make these donations because they think that they're basically trying to hold people hostage to these tiny windows to let people out of their union dues obligations. They begrudgingly follow the law when someone like you files another lawsuit to make them actually follow the law. And then when they know that they're probably going to eventually be on the hook for paying it back, they try to find ways to they try to go into courts that have sympathetic judges that will protect them because let's face it, without union money, where are the Democrats?
Yeah, that's right, Vicki. They spend, based on studies that we do, of just the reports that they file. These are just the reports that they file with the FECA and the Department of Labor and other files. And they spend about $2 billion every 2 years on politics and lobbying. That's by their own admission. We know it's more than that, but they're good enough to say, yeah, they spend about that much on lobbying and politics. And that's what this question's all about. The Janus decision was about lobbying and politics.
Right.
In fact, we won a major case up in the First Circuit Court of Appeals last Tuesday, where retired Justice Souter actually was on the three-judge panel saying that no lobbying could be charged to objecting members. We had a situation where a private sector union was lobbying in two different state legislatures, and they were charging workers in a third state for the cost of that lobbying. And that in the legislatures had nothing to do with their bargaining units. It was really amazing. We'd won that in the Beck decision back in 1988, but the unions continue to push the envelope, expand it. And then you got to find someone with courage to stand up and fight. We did find one up there, a nurse who is now living in North Carolina doing work again, but she won a First Amendment case that was very significant. But it's just, Vicki, as you know, we've talked about this so many times about just having to push, having someone with the courage to stand up and be counted.
Yeah,
and it works.
It always works. Luckily, you've been able to find people who are willing to contact National Right to Work Foundation and say, help me, I need help, because I think that my union's in violation of the law, as we have seen in multiple cases, including here in Wisconsin, about people trying to get out of their union obligations after they learned that they had the freedom to do it after Scott Walker signed Right to Work. And what ends up happening is they have to call a lawyer in order to get their rights protected under the law that is as clear as a bell. So what do you expect on October 9th? What is your gut tell you about whether or not the Supreme Court will accept these cases?
Yeah, well, what we have to find, and this kind of operation of the Supreme Court is super secret. Now, we know just enough about it to be intrigued by it. And apparently, the 8 justices will go into their conference room, and they will. Chief Justice Roberts will say, "Okay, Janice, if you ask me number 2, anybody interested?" And if you get 4 people to raise their hands, that means you might get an oral argument, and that's what we're looking for. We have 4 justices who've come down on the side of the First Amendment when it comes to compulsory unionism and forced fees. So we hope that there's interest there. The interesting part about this case, Vicki, has been held over. I think this will be our 4th conference where it was held over. In some circles, they say that increases the probability that they'll hear the case, and some says it diminishes it, or some says someone's fighting for you, but they don't quite have the votes yet. So we'll see. On October 9th, they'll usually release the orders on the following Monday, which I guess would be, the 12th or whatever. I don't have a calendar in front of me, but the 12th, they will release orders, and you'll know whether you get a chance or not, or they may hold it over, and if you don't see the name on there, hopefully you'll see it under a petition granted. That would be what we'd like, and then we get to argue the case in front of the court. But
right. But that's next year, right? But then next year you would argue the case potentially in front of the court.
Yeah, likely. I think the November, December arguments are already set up, and they're carryovers from last session. But yeah, we'd probably argue in January, February, March. Importantly,
and you need 4 justices to say, yes, we will hear potential oral arguments on this case. So you don't need 5, you need 4. That's a good thing, Mark.
Yeah, I hope so. Although we've been rejected enough that if I knew this strategy in high school, you'd get 1 out of every 100. I would have asked 100 girls to go out with me. Unfortunately, I only asked 1, and it didn't end up well for me. So I don't know, but we just keep asking.
You should have asked 100, Mark. Thanks for coming on the program. It's a really interesting case. It's got a major impact if, in fact, the unions are forced to actually pay back dues